Good evening, everybody. Let me start by welcoming Mr. Bapu Malcolm, one of our most popular speakers at Money Life Foundation, who speaks on a very popular subject. Everybody has a lot of money these days. Everybody wants to make a will. And Mr. Malcolm has been very kind to spare the time to come and speak to you and talk about how you go about leaving your assets whenever we request him. And we request him, and we've got a whole number of feedback forms which say we need another session on wills.
Good evening. Miss Dalal has obviously tried to scare you. I don't bite. As a lawyer, I might bark a bit, but I don't bite. First of all, I am thankful to both Money Life and you people. We are having this as the fourth session. Obviously, people like to hear me talk. Wills is something that is close to everybody's heart. And obviously people have something to give away. We have a presentation here which we'll run through initially, and then we'll find out what specific problems are and how to solve them. We would like a little bit of a difference from the formats we had in 3 sessions earlier, because I too would like to do something different, something new. Anyway, we'll start off with this. The first thing is wills, nominations and other issues. We will first talk of wills only, okay? Now you see here, there's a will. I don't think I need to tell you what a will is. Do you want me to? No. It's a document where you give away something. And when do you give it away? So that is a piece of paper until the person kicks the bucket. Until then, it has no value whatsoever. That defining second makes that piece of paper all important. Now under a will, you can give things away. TOA is a power of attorney. There are problems with insurance, there's problem with trusts, nominations, Hindu undivided families. All sorts of things come into play when you are writing a will. A will is a legally valid document that allows you to choose who gets what from your set. Now here, it has to be self-earned. You can't give away something that is not yours. Any person who is not a minor and is of sound mind, obviously, any legal document, you not only got to be of a sound mind, but you also cannot be coerced into it. It should be very free. Person who dies intestate is they say person died intestate. It means he died without a will, or possibly he made a will and you can't find it. It's lost. You can only bequeath what belongs to you, self-earned, otherwise you cannot. May I have the next one, please? Hindu succession. Now, the term Hindu is more or less a negative connotation. A Hindu is a person, not a Christian, not a Parsi, etc., etc. Indian Succession Act applies to Christians. Parsis do have that, but it's more or less the same since 92 when it was brought in line. Muslim succession laws are not codified, are based on their religious texts. There's a difference between what Shias can do, what Sunnis can do. Armed forces. Now here we had a few discussions earlier. There's a special provision. A privilege is given to people in the forces. at the last moment, a man or a woman these days, might realize that may not survive the next battle. At that point, they are allowed to tell the person next to them, maybe even a friend, as to how they would like their assets to be distributed. But personally, I don't think somebody should wait that long. Before you go to battle, you have to make a will. There's something that just came to mind. Amongst Parsis, before going to battle, there is a possibility of special prayers that can be performed, which normally would be performed after you are dead. The prayers are performed in advance so that prayers, in case the prayers cannot be, you may not be able to go through them afterwards. So I think a will is equally important. Condition or contingent wills. Conditions means you want to give, say, X amount to somebody or Y thing to somebody. You make a condition. Normally the condition is if my daughter marries such and such a fellow only, then she can get that money. That's the normal condition. But to tell you frankly, that can be challenged. But otherwise, contingent wills could be conditional wills and contingent wills. In fact, I brought the book with me today. Usually, it's meant for children. Person attains 18 years of age, 21 years of age. Only then can it be completely vested in them. Until then, they have just an interest. The idea being that if it's given to the child, never know what can happen to it. 18 is supposed to be an age when people are in they know their responsibilities. Joint wills, usually between husband and wife. H husband, W wife. If H dies, everything goes to W, and W dies, goes to the children, or the other way around. Mutual wills are also between two people, maybe even three. There's nothing that says there should be only two. But to tell you the truth, I'm not very happy with mutual wills. Even joint wills are proving to be a problem. But sometimes one spouse wants a will, the other spouse doesn't want a will. So between the two of them, they say, "Chalo, joint will bana lenge." We get moving somewhere. Why make a will? First of all, if you have a well-written will, well executed, well documented, it avoids problems. You don't spend money on lawyers. You don't spend money on legal cases. You may have to go to court, but not in an adversarial capacity. It's only a matter of going to court to get the routine work done, maybe a probate. You can repeatedly revise your will. I think the other day we had talked about it, that anybody who is over 18 years, the day you are 18, start writing your will. No matter what it is. You might have an old bicycle, set of books, maybe a pen. Start writing your will. You never know what's going to happen tomorrow. And the will can be changed. We'll come to that, how to change it, what to do with it. To ensure your money goes to the desired person or the charity. We'll also come to that. In fact, I would like one of you to remind me about this charity bit. We had discussed this some time back, but there has been a change in the law of which I was not aware. And most people are not aware. My wife insisted that she look it up. She researched it. And just this morning, she sent me an SMS. I looked it up too. Appointing of executors. Now, you're the managing director of a company. You want it to run. Obviously, you can't run it yourself. So you have a manager, you have managers, etc., etc. In this case, the managing director does not exist. Still the company has to run. Still the bill has to be executed. You need people, reliable people, people that you can trust, to make sure that your will, the assets that you have, are properly divided. There is no hassle. To appoint testamentary guardians. You make a will. Your children are 8, 10 years old, 12 years old. You make a will, you're in good health. You don't expect anything to happen to you. But tomorrow, you could get run over by a bus or a truck or whatever it is. Your children are too young to receive what you have left them. Primarily, now think of it, you might give something to a child of 10 years. How long would he be able to hold on to it before somebody swindles him out of it? So, if you have youngsters, children, it might be a good idea to name somebody to look after their bequest until they are 18. No court is going to allow them to touch that until they are of age. A will must list and documents, as we've said before, it's like a balance sheet. You have things, whatever you own, your assets, and how they are to be divided. It's just A to B, C to D, E to F, that sort of a thing. But make it very precise. Must be signed by 2 witnesses. 2 witnesses suggest that they be as independent as possible. Don't keep 2 witnesses from the same family. Just like I would not recommend you keep executors from the same family. Families do get wiped out in accidents or fires or whatever it is. You don't want to lose everybody. So keep them as distant as possible. People think of advocates or chartered accountants or doctors. Doctor may be, because he could certify that the person who is signing the will, the testator, is of right mind. And the witnesses will have to, if necessary, say that it was not done under coercion. Person was independent. One of the ways of doing it is, while signing, don't keep anybody else in the room except the witnesses. Now, witnesses are not supposed to read the document. There is no need for them to read the document. Every page of the will must be signed by the testator. Actually, what you do is initial it. Now, if this is the page of a will, please don't initial it here. Initial it here. The last word, just an initial, so that there can be no additions or subtractions. Each page, please number it 1 of 5, 1 or 2 of 5, 3 of 5, that sort of a thing. Ideally, at least when we make wills, we stitch them up and seal them. So that, because with computers, pages can be removed and added on. But anyway, we'll come to that also later. Law does not prescribe a format of wills. You can write it on a piece of paper, any paper. Somebody says that it must be done on stamp paper. No. It is not at all necessary. Just ordinary paper. Ideally, I would like it if your hand is legible, please write by hand. That would be ideal. Can be on plain paper, holographic. No stamp duty is payable. The idea is that a making of a will should not entail any expenses other than that piece of paper and the ink. The idea is that people should leave behind a will. And the best way of doing it is to make sure that they don't have to spend on it. Registration of a will is not mandatory. We've had a lot of discussions on this, but the fact remains there is no need to register a will. Full stop. A will can be revoked or updated. Every day you could write a new will. But make sure that you have 2 witnesses to sign it. Your witnesses might get annoyed. A will can be updated through a codicil. Now, what's a codicil? A codicil is an addition or a subtraction or a small change to a will. You might not want to, if you make a will of 20 pages and you have one paragraph which needs a little, or maybe you appointed 2 executors from the same family. Accident, both die in the accident. You can always make a codicil saying I'm appointing so and so and so and so as the executors. There is no limit to the number of executors that you can have, but as far as possible, at least keep the beneficiaries as the executors, because an executor can refuse to execute your will. There's nothing, no law which says they have to do it. So if the beneficiary is one of the executors, they will make sure that the will goes through. Law does not prescribe a format. Yeah, a will. Yes, a will can be updated through a codicil and a residual clause. Always in every will, please have a residual clause. You might have 100 rupees today. Tomorrow you might have 120. What do you with the other 20? So have a residual clause that from today, if I'm able to accumulate any further assets, they should be divided in such a way, such a way, such a way. The ideal thing to do is to say anything residual should go to this one person. Less hassles. If an executor is appointed, she must be clearly identified. Yes, I've seen a lot of wills. In fact, I've got one in my bag just now. Just the name of the person and a signature. If you are living in Baroda or in the 80s, Baroda had 22 pages of Patels, telephone directory. In Bombay, we had something like 41 or 42 pages of Shahs. And Chandu Bhai Shah or Bipin Bhai Shah are so common. So please make sure you can identify the person, what his profession, his or her profession is, his or her age is, the address, and please take their permission. Don't just write names of executors, take their permission. Probate is simply to get a copy of the will validated by the court. Immovable property suggests get a probate. It helps things move faster. But if there is no hassle amongst the family members, no fights. In fact, I have that too with the will that I got in my bag. People saying that we are not interested in the assets of that particular person. In that case, I don't see any reason why you should go in for a probate, because it's an expensive and time-consuming proposition. Minimum 75,000 rupees and maybe a year or so. Companies prefer to recognize wills. I mean, I can ask you for a million things. Get me this paper, get me that paper. It's always very easy to say no. If anybody gets awkward with this sort of thing, please ask them, show me the law. And if they tell you that's what we have been doing, please tell them that what you have been doing is wrong. It's high time you correct it. You have to be firm on this. Otherwise, they'll make you run around all the time. So you have to be firm on this and say, this is it. Gifts while alive are considered inefficient today because of the new tax risk, because you have to pay on that. So insurance is an obvious part of succession planning. The beneficiary gets death benefits, but premium is a cost. I think Money Life people will be able to help you out much better than I can on the insurance matter. Single breadwinner families, it also makes sense to have an insurance. Yes, obviously. I mean, most people today like to have a house of their own. Can't really afford it, down payment. So it's the EMI method. You take a loan from the bank or an institution. Single person earning money, he earns it, pays the EMIs. Suppose something happens. If I'm not mistaken, I think nowadays banks insist on insurance, don't they? if it's a single, they want some sort of an insurance so that this possibility is covered. If a man buys a policy under the Married Women's Property Act, the proceeds cannot be attached by the creditors. There are a few things where the creditors cannot lay their hands on. It's almost like provident fund. The idea is that a creditor cannot drive a person into the ground. Decent living must be available to everybody. A trust can be registered. You can, if you want to form a trust and expect your assets to be put into that trust, you can do it. In fact, do it while you are alive and make yourself the trustee, so that at least while you are alive, you know how to run it. You can transfer funds and property to the trust, which becomes the holding vehicle. Trustees manage the trust as per the trust deed. Please make sure that the objects of the trust are very clear. And as I said, if you run it for a few years as a trustee, you'll come to know if there are any problems. You can assess, you can assess and control assets while you are alive. That's exactly what I've been saying. Trust procedure. Next, please. A trust is especially useful when you have to provide for a special yes. You have a child in need of special care. Even after 18 or 21, may not be possible to look after himself or herself. You can provide a trust. But then make sure that the trustees at your point are decent, reasonable people. It remains out of the creditor's clutches, confidentiality is maintained and beneficiaries are not disclosed. Fair enough, because it's already in the trust. Trust carries highest taxes in India plus administrative expenses. There used to be a time when institutions used to run your trust for 1% of the assets. Even in those days, I used to think that 1% of the assets was a big amount to run a trust. Because whether the trust is of a lakh of rupees or 100 crores, the work is almost the same. Efficiency will depend on honesty of the trustees. They can select your trustees with care.